Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which I've reviewed before. This is on international trust laws and it's been written by Paolo Panico. It's a very good book from Oxford University Press. Elizabeth and I talked about the book and she's written the review this time. I wrote the previous one, but she's written most of this review, although it's been sort of added to and bits and pieces have come in. We've given the title of our book review the following: A Global Approach to Trusts, now in a new edition from Oxford University Press. Let's have a look at the book first of all. Nice blue cover there. There we go. It's a heavy book, hardback of course. There's the spine, there's nothing on the back. You see the spine there. It's a heavy book. It runs to nearly 850 pages. The index at the back is paragraph numbered, and it's pretty detailed. You can see what you've got. You've got paragraph numbering at the sides and you've got footnoting. So you've got all the usual suspects there, trying to find what's in it. There's the front page there. And then you've got the usual information from OUP, and you've got a dedication. I'm going to mention a bit about the dedication in a moment because it involves a cat. We're going to talk about that in a minute. There are 15 chapters. Excuse me. 15 chapters. There's the contents there. It finishes off with the quizclose trusts. You'll be interested to read that. Certain people of my vintage will, because we remember the case when it came in. There's the much more detailed contents section, running all the way through the various rules. Then the table of cases. You can see the cases are listed by country, which I think is, again, very helpful, because it is an international book, and of course UK cases are fairly substantial. But you've got a wide range of cases. Then you've got the tables of legislation, again with that international instruments, EU, and then the various countries all the way through. And then after that runs through, we get straight into the introduction itself. The English legal genius that attached an obligation of conscience to the title to property brought into being what Frederick Maitland famously described as perhaps the greatest and most distinctive achievement of English lawyers. We'll come on to that in a minute. Since their first medieval appearance as uses, trusts have established themselves as the main estate planning and wealth management arrangements of the Western legal tradition. And I'm going to spend a little bit of time talking about that because the concept of the trust is a very, very interesting one, and it baffles, I have to say, I've spoken to people in other countries, it does baffle one or two people. But let me talk about the book anyway. Lawyers advising international clients on matters relating to trust will welcome this new edition of International Trust Laws from OUP. Here, presenting a truly global approach to the subject across no less than 30 jurisdictions, we've counted them, worldwide, with the largest number of cited cases emanating from the UK, of course, and the US. Scotland and, predictably, Jersey also loom large in this thorough and erudite examination of virtually every conceivable aspect of trusts. And that's what Panico has aimed for. Trusts themselves, says the author, Professor Paolo Panico, have established themselves as the main estate planning and wealth management arrangement of the Western legal tradition, right at the beginning. Repeated because that's the basis of it. Trusts, along with trade and tea, he adds, were one of the three T's traditionally associated with British civilization. Good thing that Henry VIII failed in his attempt to legalise them out of existence in 1535 then. The author quotes a particularly famous comment on trusts as perhaps the greatest and most distinctive achievements of English lawyers. That's Maitland again. So again, I'm repeating that because I think it's really fundamental. It's a fundamental understanding of where we are. Then, since the first edition of this distinguished work was published in 2010, for that matter long before that, trusts have become notable excuse me, for their popularity and ubiquity internationally. And of course, to the surprise of some, they become popular under special legislation in what the author refers to as, quote, jurisdictions with no historic contacts with the rules of English equity. In other words, civil and mixed jurisdictions in Asia, Latin America, and recently Eastern Europe. So the trust is not had its day at all. It's still there, and it's a wonderful instrument that can be used. I would say that though, but I'm a member of Lincoln's Inn, so I'm bound to be a little bit biased. Now, over 14 chapters and more than 850 pages, Panico pursues this vast and complex subject with scholarly yet cheerful thoroughness. Trusts, he said, have traditionally been used by individuals to establish rules governing the administration and enjoyment of their property after their death, and in many cases to retain a certain degree of control over said property during their lifetimes. There are, of course, almost innumerable variations, ramifications, and so on, pertaining to trusts, which are carefully elucidated in this book. And I'm not going to spoil it for you, you can read them for yourself, but it's a detailed book. Here, then, is an area of law which cannot fail to be taken seriously by serious players. So it's refreshing that we discover in the book's list of dedications that it has been written at least partially in memory of the author's family cat, a Manx, a presumably tailless and engaging creature, who sadly died before the book reached its definitive printed version. Now, however, a kindly fate intervened in the shape of Scotia, a kitten, presumably Scottish, who emerged from under a fence to provide further inspiration and encouragement as a psychotherapist. We neither. Fortunately, we reformed in the note that psycha is the Romanian word for cat. And it cannot be coincidental then that chapter 13 of the book, in discussing the approaches taken in various jurisdictions to enforce non-charitable purpose trusts, refers to specific rules for exceptional cases, such as trusts for commercial transactions and trusts for the care of pets. Now, I'm not being flippant at all. I thought it was a lovely dedication, but I thought that was a nice little approach that we could adopt with the review. Certainly Elizabeth did, and I agree entirely with her, of course, on that. The book's orientation is global, its subject matter vast and detailed, and it covers analyses of the laws and often parallel as well as contrasting approaches to trusts over a range of jurisdictions. It purports to identify trends and developments, explains the author, but does not attempt to provide a comprehensive operational guide to the laws of any particular jurisdiction. I think that must be left to those individual jurisdictions, and of course you will have a wealth of additional case law and authorities in those jurisdictions. Let me conclude by saying this, that its useful comparative approach, however, will obviously be of special interest to comparative lawyers as well as academics and law students interested in or specialising in this rapidly expanding field. Furthermore, with its detailed index, table of contents, extensive footnoting, and the 60 pages of tables of cases and legislation, the book is reassuringly easy to navigate. Every international lawyer, we think, should have a copy, and the publication date is cited as at 2017. Let me just have one last look at the book. It's a heavy book. There it is. There's the spine. There's not a lot actually on. There's nothing on the back. It is a heavy book, as I say. It runs to nearly 850 pages. The Quist-Close trusts right at the back. I never really understood them for years when I was a student, but I do think they're very well explained here. So if you are interested, certainly if you're going to practice in law in the trusts area, that would be something you might like to have a good look at, because I thought it was a very, very useful explanation of how they work. We're looking at trustee exemption clauses here, right in the middle of the book. You see the paragraph numbering, very helpful. Footnoting, of course, as well. And as I mentioned right at the front, there's the nice thing about the cat again. Do have a look at that, because I thought that was very important. The contents section are very detailed. There's a very simple list of the contents, and then you've got a lot of detail. And you should be able to find things. Non-charitable purpose trusts, wonderful area of law, especially important. I think this would be something that anybody looking for a first with their undergraduate trust paper would find this book well worth having a little perusal. But thank you very much to Paolo and to everybody else at Oxford University Press for this excellent book. Most impressed with it, and very grateful that you've taken the plunge to give a new second edition and updated everything. Thank you very much to all. Found it a fascinating read. Bye-bye.